Welcome to today's program titled Critical Information for Year-End CTA Compliance. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker. Susie, you may begin.
Thanks, Joanna. Welcome, everybody. We're going to spend a little bit of time with you now just to talk about critical information for year-end CTA compliance. I'm sure you've all heard of CTA. You wouldn't be here if you hadn't. If you're like everybody else we've talked to, their first impression is, I don't know what it is and it can't possibly apply to me. But in our experience, there's wide-ranging application of CTA really to every entity that's been formed in the United States. And the US government is estimating there are about 38 million entities. Now, a small number will be fortunate enough to have an exemption, and we'll get into all of that as the program takes place, and I hope we'll be able to answer all of your questions. Why don't we go to the next page, Joanna? The panelists for today, myself, I'm a longtime corporate partner at Seyfarth. I head up our M&A practice. I would like to say against my will, I had to be active in our CTA task force, really largely because it affects every client that I've ever worked with. And I figured I might as well get on top of it so I can answer questions. And then I have two really terrific colleagues that I work with a lot, Shameen Mohandesi and Brianne Vaklovic. Shameen, let me turn it over to you just to say words about yourself, and then you can turn it to Brianne just for a quick intro.
Sure. Thank you, Susie. As Susie mentioned, my name is Shameen Mohandesi. I'm a corporate associate here at Seyfarth Shaw, working out of our Seattle office. I spend the vast majority of my time on M&A and institutional investments, and I often work with growth companies who routinely are reaching out and expressing their shock that they may have obligations under the CTA. Brianne?
Thanks, Shameen. My name is Brianne Vaklovic, and I'm a senior associate in the corporate department in Seyfarth's Chicago office. And my practice heavily focuses on M&A and also corporate counseling.
Excellent. Thank you both. Let's go to the next slide. So what are we going to cover today? We are going to cover a broad overview. We're going to talk about what is CTA, what's a reporting company, what are the required filings and the timing. We're getting nervous, getting close to the end of the year. Who are beneficial owners, and what is a company applicant, and why do I need to care? So that's what we're going to cover. We're going to do a broad overview. I know you may have an opportunity to send questions in. If we can get to those at the end, we will do that. We otherwise will do follow-up after the program. So we appreciate your questions. And we really hope we know the answers, since all of us are kind of learning this at the same time. So what is the CTA? Now, the Corporate Transparency Act of 2020, as you can see, was introduced in Congress in 2020. It only went into effect legally on January 1st of 2024. This really is the United States coming into line with almost every other country in the developing world, where there is substantially more transparency on who owns a company, who the significant owners are, who the significant control parties are. This entire initiative by the US government is intended to stop money laundering. Now, the vast majority, maybe 99.9% of those 38 million entities in the United States, they weren't formed to do money laundering. They're not trying to hide anything from the federal or the state law enforcement agencies, but there's a very broad brush. And so, again, this is the United States coming into line almost with world order on these sorts of disclosures. And an important thing to keep in mind, the information that you submit with a filing is confidential. It's submitted online to the US government. Initially, it can and will be shared with law enforcement, which probably isn't going to impact anybody on this webinar. And longer term, it may be available to other institutions such as banks. But frankly, when you deal with your bank or you open a bank account, you already go through extensive KYC, know your customer disclosures. And frankly, banks probably would only be looking to see is what you file, if you file, consistent with what you've told them. So again, the CTA wants to, get disclosure on entity ownership and prevent money laundering where shell companies are set up and it's very secretive. Nobody knows who really controls it. Now, I'm sure all of you know filings are made with FinCEN. That's the Financial Crimes Enforcement Network. And if you haven't been there, FinCEN's got a robust website, fincen.gov. It's easy to go there. There are a lot of resources. We'll talk more about it as we get into the presentation. Joanna, next slide, please. So this is why I started taking CTA seriously over a year ago, because I've been in corporate practice for a long time. I don't do anything that deals with criminal penalties, like nothing. There's nothing. I mean, it's plain vanilla. Corporate M&A, if there's any hiccup, it's a civil issue. It's never a criminal issue. The thing that made me really take CTA seriously is there are criminal penalties. If you fail to file, the first thing they do is they start assessing penalties. They're up to $591 a day. It'll be adjusted for inflation. And they're criminal penalties, fines, and up to 2 years in jail. Listen, we'd be shocked if anybody that we've ever done business with is going to have a civil or a criminal penalty under CTA. And that's not what the U.S. government is likely to start focusing on early on. They're looking to get voluntary compliance with the disclosures. And over time, we'll see what happens with enforcement. But my feeling is you've got these entities. Why be in violation of a statute that's got criminal penalties? It's not a good look. You're going to have to give reps and warranties, likely in certain documents. You'll have to file certifications. And it's just really not worth the risk. And I think in the end, you'll see that it's going to be easy enough to do these filings or to find an exemption. So hopefully this is not something that hangs over anybody's head for any great period of time. Why don't we go to the next slide? And Shamim, let me turn things over to you to start talking about who's required to report.
Sure. Thanks, Susie. So as the slide suggests, we're going to talk about who is required to report. We at Seyfarth take a bit of a stance on reporting obligations where we kind of begin our assessment of reporting from the assumption that every entity does have a reporting obligation. And to the extent appropriate, we may look for an exemption. But as we're speaking to all of you, we encourage you to start from that place as well. So unless covered by an exemption, the CTA's reporting requirement applies to any entity created by or registered to do business in the United States by the filing of a document with a Secretary of State or a similar office in the United States. So commonly, this refers to corporations that file a charter, limited liability companies or partnerships that file a certificate of formation, statutory trusts, sole proprietorships and general partnerships that don't make those filings, or common law trusts. They are generally not covered by the CTA. However, it's worth noting that when we talk about the Secretary of State, we heavily emphasize the concept of a similar office in the United States. So, for example, if you are responsible for or inquiring with the reporting obligations of an entity that is established under a tribal equivalent to a Secretary of State, that entity will likely have filing obligations as well. Next slide. When we think about exemptions, we note obviously that there is there are 23 exemptions that are set out in the CTA. And the way we think about those generally are exemptions that relate to entities that have other reporting obligations through some other regime where the information sought out under the CTA would be available to the federal government via this other regime. So, for example, any entity that files a report with the SEC is exempt. Government authorities are generally exempt. Banks, credit unions, investment advisors, broker-dealers, insurance companies, utilities, and so on and so forth. These are generally entities or groups of entities, classes of entities that have separate regulatory obligations where they need to file their beneficial ownership and so on and so forth. And importantly, entities may be transient. They may at one time have a filing obligation and at a later time become exempt from that filing obligation. We're going to talk about this more as we progress through the slides, but it's very important to keep in mind the 30-day period, which is generally the amount of time that the CTA provides for a filing to be made when something changes with regard to your CTA obligations. Next slide, please. We highlight 4 categories of exemptions, which we think are, obviously a minority of the total number of exemptions, but perhaps the most relevant to those in attendance here today, and generally the most commonplace in our experience. So the first and perhaps most common one that we come across is the large operating company exemption. And that relates to any entity that employs more than 20 full-time employees in the U.S., has an operating presence at a physical office in the U.S., that owns the entity, that the entity owns or leases, has filed a federal income tax or information return in the U.S. for the previous year demonstrating more than $5 million in gross receipts or other applicable forms that it may file, excluding gross receipts or sales from sources outside the U.S. Importantly, in the case of the large operating company exemption, some of the consolidation or aggregation that we see under kind of legal standards does not apply in the case of the large operating company exemption. So, for example, if a single entity has a number of subsidiaries, each of which has 5 full-time employees, which in aggregate are 20 full-time employees, that would not be sufficient to meet the large operating company exemption. Another note that there has been some updates to the FinCEN FAQs on beneficial ownership reporting, beneficial ownership information reporting rather, that have more recently indicated that in the case of a large operating company which is largely remote, the address of a registered agent may be used as the address provided in the CTA filing. Next, we turn to tax-exempt entities. Obviously, that's a broad category of exemptions. Wholly owned subsidiaries of certain exempt entities. And it's important to note that when we say wholly owned subsidiaries, we do in fact mean wholly owned subsidiaries. If an entity has 2 exempt parents, that does not exempt that subsidiary from its filing obligations. And then an inactive entity, which we'll describe in a little bit more detail. Next slide, please. Inactive entities are perhaps different than what we might kind of conventionally assume they are. To qualify for the inactive entity exemption, an entity must be in existence before January 1 of 2020, not be engaged in an active business, not be a foreign person, directly or indirectly or wholly or partially, not have experienced a change of ownership in the past 12 months, not have sent or received more than $1,000 in funds in the past 12 months, and not otherwise hold any assets, including equity interests. It's worth noting that threshold for, the dispatch or receipt of funds is fairly low, and, it will likely take many companies kind of out of that exemption. It's worth noting that the obligation to file for a company that is otherwise a reporting company really comes into effect as of the beginning of 2024. That means that if you have a company which you have wound down, or you're responsible for a company that has been wound down, and in calendar 2024, that entity must still make a BOI filing, or a CTA filing rather, for its ownership, even though it may not exist come the end of this year. Next slide, please. So here we turn to the required filings and due dates. And admittedly, this is this table is very quickly coming up against the end of its relevance as we approach the end of the year. But in short, we kind of think about entities and their reporting obligations in three buckets. There are the kind of the pre-2024 obligations and timelines. So that's the entities existing as of December 31, 2023. There is the bucket that affects entities formed or existing, I guess really formed in 2024, so January 1 to December 31 of 2024. And then there's January 1 of 2025 onward. So for entities existing as of December 31 of 2023, their obligation is to file beneficial ownership information. And that obligation needs to be met by January 1 of 2025. So essentially the end of this year, those entities need to file their beneficial ownership information. And at the front end of this presentation, when Susie mentioned that there are something like 38 million of those entities estimated to be out there, that's the bucket that we're referencing. For entities formed prior to 2025, January 1 of 2025, those entities prior to the beginning of January 2025, but after the beginning of 2024, those entities have 90 days to file both company applicant information and beneficial ownership information. And we're going to get into the nuances of what those different reporting packages are. And then for any entity formed on or after January 1 of 2025, there's a 30-day clock on making both the company applicant information filing and the beneficial ownership information filing. The filing system is online through FinCEN's website. Of course, there are a number of third-party services that might interface with that website or make the filing on your behalf. And updated and corrected reports are generally required to be filed within 30 days of a change or discovery of the inaccuracy. So we'll talk about some specific instances when that might become relevant, but generally it's a 30-day kind of clock to remediate any filings. I think we'll jump ahead to the next slide, required disclosures. So finally we come to, or finally for me at least, we come to the required disclosures as to the company and as to the beneficial owners. So it's important to remember that a reporting company needs to file its business information, and separately its BOI information, which is kind of a different group of information that needs to be provided to FinCEN. So as it relates to the company, you need the full legal name of the company, any trade names or DBAs, the current address in the US of the principal place of business, the state, tribal, or foreign jurisdiction of formation, and the taxpayer identification number, or EIN. And as to the beneficial owners, it's the full legal name of those beneficial owners, the date of birth, current residential address, and whatever's the unique identification number and issuing jurisdiction and image of either a passport, a driver's license, tribal ID, et cetera. I think with that, we'll pass it on to Brianne.
Thanks, Shamim. So there is something called a FinCEN ID, and what this is a unique identifier that's issued by FinCEN to an individual or reporting company who will be involved in beneficial ownership reporting. FinCEN, the ID allows the beneficial owners and company applicants, which I'll get to a little later in the presentation, to submit all the personal information that Shamim just went over directly to FinCEN rather than having their details disclosed every time a reporting company files a report. And the key benefit here to obtaining the FinCEN ID is really privacy and efficiency. Once a beneficial owner or company applicant obtains their FinCEN ID through the FinCEN website, the reporting company only needs to reference the FinCEN ID number. And this reduces the burden on the reporting company, especially if a person is involved in multiple entities. It also provides an added layer of data security, as the sensitive personal information won't have to be repeatedly shared in every BOI report. It is important to note, though, that the responsibility to update the personal information shifts to the FinCEN ID holder. If there are any changes, such as a change in address or a new ID card was issued, it's the responsibility of the FinCEN ID holder to update that information. And as of now, this obligation is lifelong. The most recent FAQs do indicate that FinCEN is assessing options to allow individuals to deactivate a FinCEN ID so that they don't need to continue to update the underlying personal information on an ongoing basis, but there hasn't been any further clarification on that, so stay tuned on that one. From a practical perspective, we strongly encourage everyone that is going to be involved in BOI filings to obtain a FinCEN ID. Us lawyers got a FinCEN ID, as soon as we were able to. It's really just a small step that can streamline compliance for both the individual and the reporting company, and is likely to become best practice, which I know we'll get into best practices a little later in the presentation. Next slide, please. Who are beneficial owners? So when we talk about beneficial owners in the context of the CTA, it's really a lot broader than what you're probably used to in terms of KYC, know your customer, information that you disclose, in that department. So under the CTA, we're really referring to individuals who have a significant role in either the control or ownership of a company. And it's critical to understand that the test for identifying beneficial owners is not an either-or test. It applies both to individuals with substantial control over the entity and/or those who meet the ownership threshold of 25%. And so I'll break it down a little further with this two-prong test. So substantial control test, this is the first category of beneficial owners. And it includes those who exercise substantial control over the company. This is intentionally meant to be a broad concept and to capture anyone who has significant influence over the company's decision-making process. Substantial control doesn't have to be direct. It can be exerted through a variety of indirect means. And some examples of substantial control include serving as a director or senior officer, for example, a CEO, CFO, or other key executives, appointing or removing senior officers or a majority of the directors. This could include individuals or entities who have the power to control the leadership structure, even if they don't hold formal positions within the company. Another one is making or approving major decisions. This includes decisions about strategy, business plans, mergers, significant financial investments, or changes in the company's structure. And then importantly, another one is negative control. So this is a crucial point. Even if someone doesn't actively make decisions, they may still exercise substantial control through veto power or the ability to block significant company decisions. This could be, for an example, an investor or partner with a minority stake, but the ability to block decisions on mergers, acquisitions, or other critical business matters. So again, the substantial control test is really designed to capture a wide range of individuals who could have a meaningful impact on the direction and operations of the company, even if they don't officially, quote unquote, own a significant percentage of it. And so this is especially relevant for entities that have complex governance structures or are owned by multiple parties. The ownership interest test is a little more straightforward in that it's based on ownership interests, which includes any individual who owns or controls 25% or more of the company. This goes beyond just holding stock or membership interest, though. It covers rights that could convert into ownership as well. So what qualifies as ownership is, again, direct ownership. If someone holds 25% or more of the entity, they are considered a beneficial owner, or indirect ownership. This applies when an individual's ownership is through another entity. For example, if someone owns a majority stake in a holding company that in turn owns 25% or more of the reporting company, that individual is deemed a beneficial owner. And convertible instruments. So this is where things would get a little more technical, but convertible instruments like warrants, options, convertible notes also count toward the 25% threshold, even if those instruments haven't been exercised yet. And one important caveat I'd like to mention on the indirect ownership is that ordinarily when a corporate entity owns or controls 25% or more of a reporting company, the reporting company must report the individuals who indirectly exercise substantial control or own 25% or more, not the corporate entity itself. But there are two special exceptions here. A reporting company may only need to report the name of an exempt entity if that entity is exempt for one of the 23 exemptions that Shamim mentioned. Then that exempt entity name can be disclosed in lieu of the individual beneficial owner who actually owns or controls the ownership interest in the reporting company. If the beneficial owners of the reporting company and the intermediate company are the same individuals, a reporting company only needs to report the FinCEN identifier and full legal name of the intermediate company through which an individual is a beneficial owner of the reporting company. So this only applies to shield the individuals who are beneficial owners of a reporting company exclusively by virtue of the individual's ownership interest in one or more exempt entities. It does not apply to shield beneficial owners who exercise substantial control of a reporting company through an exempt entity. So again, these tests apply simultaneously. This means a person can be considered a beneficial owner if they meet either or both tests. A person with substantial control over the company but less than a 25% interest is still a beneficial owner. And likewise, someone who owns 25% or more of a company but perhaps isn't involved in day-to-day decision-making would also qualify as a beneficial owner. It's possible for an individual to meet both tests, which would, further solidify their status as a beneficial owner. And then I think we can go to the next slide. Okay, so we'll talk about company applicants and the information required for new entities. So this is a specific category of individuals who only need to provide information for newly formed entities that are created or on or after January 1, 2024. For these individuals, the same information is required as for beneficial owners, which Shamim previously laid out, which would be the full legal name, the date of birth, business or residential address, and the identifying number from a government issued document. However, unlike beneficial owners, the company applicant's information does not need to be updated after the initial filing. And this is a critical difference. For example, if a company applicant no longer has a relationship with the reporting company, there's no obligation for the reporting company to update their report to remove or replace the company applicant. A reporting company created on or after January 1, 2024 is required to report company applicant information in its initial report, but there's no updated reports required on the company applicant changes. Another point on the company applicants is that they can provide a business address instead of a residential address. And a FinCEN ID is also an available option for the company applicants. This eliminates the need to provide all of the personal information of the company applicant. Next slide, please. So this actually brings me to who are company applicants. A company applicant is defined as an individual who directly files the document that creates or registers the company. And if there's more than one person that's involved in the filing, the individual who is primarily responsible for directing or controlling the filing. Often this is going to be an attorney and an employee of the reporting company or an employee of a service provider if a service provider files the reports on the company's behalf. To determine who is primarily responsible for directing or controlling the filing, you want to consider who is responsible for making the decisions about the filing, such as how the filing is managed, what content goes in the document, and where the filing occurs. There can be up to 2 company applicants listed in the BOI report. This is particularly relevant in larger entities where there's multiple professionals. And how you want to, actually consider who's making, the decisions about the filing when you're considering who 1 or 2 company applicants are going to be. In practice, like I mentioned, it's usually an attorney because we, create or draft the actual certificate or articles, and the other applicant is, typically a service provider if you choose to have a service provider file on your behalf. Next slide, please. Helpful resources. So as Susie mentioned at the beginning of the presentation, there's a lot of complexity on the reporting requirements, and it's really important to take advantage of the resources that FinCEN has made available. This includes the filing portal. All reports are filed online through FinCEN's website. So, take the time to familiarize yourself with the portal now in advance of the filing deadline. FinCEN also has several video demonstrations that can walk you through the process of actually filing the report, which is, particularly helpful for the first-time filers. There's also FAQs that have been, continuously updated, and filing instructions. These are very detailed and, provide a lot of answers to, some of the trickier aspects of the filing process. Another one is the Small Entity Compliance Guide. This is useful for smaller companies. And we also, Seyfarth has a lot of resources on our page too. So these are all hyperlinks that you can pull from the slide deck, after the presentation. Next slide.
So I'll just jump in here to cover what is kind of the last part of this presentation, which is some concrete next steps. And I'll just note that there's a fair amount of questions that have come in. We'll turn to those, and we'll kind of move through these next few slides very quickly to make sure we have plenty of time to answer questions. But we'll start with what with the end of the year kind of bearing down on us. What are the things that you all should be doing in connection with your organizations getting compliant? So we'll talk about some preliminary actions, the actual preparing and filing of the BOI reports, the post-filing considerations, and then some other general best practices. Next slide, please. So as an initial matter, we recommend identifying one person in your organization internally who will be your CTA czar, your person who's going to be responsible for monitoring the FAQ updates and keeping management abreast of any changes that would kind of be relevant to the company. Obviously that person is generally going to be working with someone externally who's staying abreast of these topics as well, but we really recommend having a key person internally. Second, adopting a company policy regarding CTA compliance. As I think it's fairly obvious just going through these obligations. There are some gray areas, and certainly Seyfarth, being kind of concerned about client risk, is very much kind of the view that when there's a gray area, a filing is valuable. But to the extent that your organization feels differently and is more tolerant of some of that risk, we recommend that the company adopt a policy regarding CTA compliance, which sets out its basis for filing or not, and puts that in its files in the event that subsequently there's some type of enforcement issue that arises. So it's not merely a we just didn't pay attention to it and didn't act type of kind of enforcement action that comes up. It should be an informed choice in either direction. Second, developing CTA-related training, in particular for those organizations that have frequently created and kind of a number of subsidiaries or affiliate entities that are going to have filing obligations kind of arising on a regular basis. We think training is very valuable. Next is beginning with the company's org chart and ownership records, capitalization tables, and beginning to determine whether each entity in the org structure is a reporting company or not. And then to the extent that any exemptions may apply, memorializing those applicable exemptions and the analysis that goes with it. Next slide, please. Next, and this is perhaps really the long pole in the tent, is once you make a determination as to a reporting obligation or an exemption, assuming you determine that there is a reporting obligation, identifying the individuals that will be the subject of that obligation or which you'll have to report their beneficial ownership information, you need to very quickly begin collecting that information. This is in particular for those in the United States, this is a new process. There's a lot of explanation and hand-holding that goes with, getting stakeholders to provide their beneficial ownership information. And as a result, there's no time like the present to start making those requests. Next is identifying all the reportable beneficial owners and control persons, obviously. That informs who you need to get that information from. Collecting that information, and where possible, getting a FinCEN identifier, the identifier that Brianne discussed and described. And then for companies formed in 2024 or later, identifying who the company applicants were. Oftentimes, this may be counsel, this may be a third-party registered agent firm like a CSC or a CT Corp. But getting all of those FinCEN identifiers or other BOI and company applicant information is kind of critical. And then to the extent that people update that information, ensuring that you're staying abreast of those updates, with the exception of in the case of the FinCEN identifier, which becomes the individual's obligation to keep their information updated. So, essentially identify reporting entities, identify the control persons and beneficial owners, collect their information, and begin putting your filings together. Next slide.
So preparing and filing the BOI report. So I think, Shamim really kind of described really the hard work that you have to do before you can actually, just put pen to paper and fill out your actual report. There are two ways to prepare and file the report. There's a fillable PDF that you can obtain directly from FinCEN's website, where you can see all the information that you need to input. And if you have the FinCEN ID numbers, it's very simple and straightforward to get that information input in that fillable PDF. Or you can log into the FinCEN portal and complete it in real time in the portal and submit it that way. But it's just really important to identify, when you have to actually file, depending on when your entity, was formed. If it was, formed prior to January 1, 2024, our new entities formed after January 1, 2024. Like we mentioned, the timing of the filing is really one of the most important aspects. Using the FinCEN e-filing system is, I think, pretty user-friendly. There's been, some technical glitches here and there, but overall, the system is, designed to streamline the reporting process, and make sure the information is securely submitted to FinCEN. In terms of actually creating an account with FinCEN, you create an account on their e-filing portal. If you haven't already done that, you can go ahead and do that, sooner rather than later, because that's going to be your hub for submitting the BOI reports and managing any future updates or corrections. Once you have all the necessary information that we already talked about gathered, you log into the system and you can complete the required fields there. For the reporting company, the beneficial owners, and if applicable, the company applicants. And then after entering the information, you can, submit it, and you'll receive a confirmation of your filing, and FinCEN will then process the information. And like we mentioned before, there's a lot of helpful resources to consult on FinCEN's website, including demo videos that actually shows you what the portal looks like and gives you the filing instructions, so it allows you to familiarize yourself with the process. Next slide, please. Post-filing considerations. So sadly, compliance doesn't end after you make your initial filing. As we talked about earlier in the presentation, companies are responsible for keeping their reports up to date. And it's really a tight timeline. As Shamim mentioned, in a lot of cases, if a change occurs, the company must file an updated report within 30 days. This would include changes to beneficial ownership. So, you have a new shareholder, which shifts, the 25% threshold. Or you have any other inaccuracy or mistake that you noticed in the original filing or you became aware of. Those things need to be corrected within 30 days of discovery. Another important one is, if a company loses an exemption during the year that they were required to report, it's a 30-day window to, file the report in that case. And then likewise, if a reporting company actually becomes exempt, for example, if they now qualify for the large operating company exemption or a wholly owned subsidiary exemption, it's a 30-day window. So, in practice, that's going to be a very short timeline. And so, as Shamim mentioned, it's important to have your processes and procedures in place at the outset, so that you're prepared to make the change, when the change happens. Next slide.
Great, thanks, Brianne. I'm just going to talk about a couple of other best practices. And listen, we appreciate that, for some of you listening, there are companies that have operating business and active assets, and others are just very simple single asset holding companies, or entities that really don't have a lot of life. So what you do with respect to any particular entity or business is going to be very unique depending on your needs. But one thing just to consider is whether or not there's anything you need to do to protect data security. There is so much more focus on privacy and data security these days, and particularly since personally identifiable information, this PII, may be collected from some of your beneficial owners and control parties. Make sure that if you're storing that you're storing it in a way that's really legally compliant. And my preference would be, don't give me that information. If I've got to report you, go to the FinCEN website, get your FinCEN identifier, which is not going to be personally identifiable information, and just give me that. I mean, I got my FinCEN identifier on January 1st this year. So since I've been company applicant for a lot of companies, I just send a V card with my name and my FinCEN identifier to clients and say, here it is. I'm not sending them my home address and my birthday. I mean, it's not really that secret particularly, but it's not like they need to have that kind of thing in their system. And, if I'm moving, I'm changing addresses, somebody changes their name for whatever reason. So something to be aware of, and look at some of your existing privacy policies too, to see if you have to do anything there. And then just on general company policies, for some of the larger companies that have active operations, you might want to see whether or not there are any documents you have that it may be helpful to add CTA related provisions to. So for example, if you're doing a fundraising and you're issuing convertible notes, you're issuing shares, you're raising funds, you're putting together an LLC agreement, you may want to have something in that agreement that says to your members, as a condition of membership or subscription, you will provide or are providing on Exhibit A, the information that will be needed in order for us to report if you're in a control position. Say you're going to be a manager, the CEO, you're going to be a 25% or greater owner. So maybe put that there so you don't have to, start begging people long distance to say, well, you didn't ask me this at the beginning. So handle it for the future. Employment agreements at the executive level, we see those mostly just at the executive level. But it's usually for people like your CEO, and you may want to have something there that is part of your employment relationship. You'll comply with our requests for CTA reporting. Same maybe for director and officer agreements, indemnity agreements if you have them. And then the other thing we would recommend, even if you've had to file on inactive entities, to the extent you can get rid of them now and get rid of your ongoing obligation to do updating other than to say it's been dissolved, maybe don't let those things hang around. Start just doing a little bit of cleanup. That's really the way to do things as far as we're concerned. I know we've done a lot of presenting. It's been a big lecture, process here. We do have quite a few questions we're going to try to run through, I think, fairly quickly. I do want to mention for those of you who are looking to have continuing legal education, CLE credit, you can scan the QR code that's on the screen and go right to our system. The attendance verification code is SS. That's as in Seyfarth Shaw. I was going to say Susie Saxman, but Seyfarth Shaw 8475, SS 8475. We'll go through a few questions and then we'll repeat the CLE verification code again, just in case anybody misses it. Or I think, Joanne, you can probably just leave that up on the screen. But Shamim and Brianne, did you want to maybe chat a little bit about some of these Q&A? I just thought I would mention on the Fifth Circuit case, there is a case challenging CTA. It's been, nothing really much has happened. I mean, my personal opinion, which is really a personal opinion since I'm not an appellate litigator, is we're coming into line with the rest of the developing world. I find it highly, highly unlikely that the CTA will be overturned. It was passed overwhelmingly in Congress, both the House and the Senate, and it was signed by the president. It's just not likely to happen. So everybody thinking it's going to get overturned between now and the 31st, I mean, you can wait, you can see, but That's not where our money is. We think it's highly unlikely. And believe me, if anything were to happen that were to put a stop or a change on these requirements, you'd have 20,000 law firm client updates instantaneously overnight, because believe me, we get calls and emails every day about this. So we'd be the first to really be, screaming out the window that there's been a change. But again, there's no authority out there that makes it seem like something like that is likely. Shamim and Brianne, do you want to take maybe a next couple or?
Yeah, there was one of the last questions was, do exempt entities need to file to register their exemption? And the answer to that is no. But I think it was Shamim who talked about you really do want to document from a company perspective how you came to the decision that you are exempt. And recently what I did is actually prepared, corporate resolutions where the directors acknowledged that they reviewed the exemptions and that they fell into the large operating company exemption, and here's why, because they met these prongs. And so for those reasons, they were exempt and did not need to file. So it's important to, not just, there's not just an email that says that we're exempt, to sort of really think about, the reasons why and to actually document those.
Yeah, hey, a quick one I want to mention. There's a question about, do we assume disregarded entities cannot be large operating companies because they're not filing federal taxes? Correct. That's been clarified, and that's a big hole in the large operating company, because there are a lot of limited liability companies out there that may have a holding company up top, maybe another LLC, and they are disregarded for tax purposes. You cannot qualify for the large operating company. I have a lot of clients I've had to do updates with just to say we were hoping that you'd be able to be eligible for large operating company exemption, but it's just not going to work. If you have two owners, multiple owners, your taxed as a partnership, then you're going to be fine. Or if you've elected to be taxed as a C Corp, even though legally you're a limited liability company. There actually are some companies to do that. That's not what we see normally, but that is sometimes the case. So that works as well. Shamim, anything you see that you want to?
Another question here just asks, can a beneficial owner be another legal entity or a parent company? And the answer is no. The CTA is looking for individuals. It is looking to understand who the individual owners of entities are, whether they're kind of, one layer up the org chart or 100 layers up the org chart. Ultimately,
Shamim, the only little nuance on that though is if you had a beneficial owner that is exempt.
True.
You might be able to disclose that entity with the exempt entity's FinCEN identifier. And that would be that would be the only exception to that, I think.
That's correct. So if there is an exempt entity does act as kind of the ultimate entity in a filing, but generally speaking, unless there's the exemption, beneficial owners are individuals.
The people. They want the people.
And following up on that, there's at least one question I saw about how strictly or the CTA will be interpreted. There is some subjectivity to this analysis, and what we recommend is as you look at your org chart and your governance, and really the influence question really becomes a question of governance. You need to understand that there is some room for interpretation, and memorializing how your analysis concluded that a particular person did not have influence, or conversely how a person did have influence, is a bit subjective. But as you saw, the language is designed to be fairly far-reaching. So, for example, if you're if a particular shareholder in a corporation has negative covenants, protective provisions, it may be worth considering whether that ultimately is a control person, or rather whether the beneficial owners of the chain are a control person. So there is we view this as being an exercise in kind of conservative risk management. And so we err on the side of, if there's some, control or influence that this individual has, by all means, let's include them as a control person. I'll also just mention one other thing. That there was a couple of questions about condominiums. So condominiums were actually one that was clarified, through the FinCEN FAQ updates earlier this year. So certainly condominiums or condominium associations may be considered exempt on the basis that they are occasionally nonprofits or tax-exempt entities, rather.
Must be tax-exempt.
Tax-exempt entities. But in the absence of a valid exemption, they are reporting entities, and depending on the nature of the association, they may not be membership organizations. They may just have a board, and so that board would be essentially be in control and have reporting or would be the reported control persons.
Someone asked about some of the reporting companies who are filing documentation to form companies. If you're using a CSC, CT, an organization like that, they will always give you a FinCEN identifier for somebody at that filing organization when they give you the filed certificate of incorporation or certificate of organization. So you will get that. You'll always get that. If for any reason you don't get it, just ask them and they'll shoot it over. It'll be a FinCEN number.
Another question here is an employee who has significant control over the direction of the company but is not a shareholder still considered a beneficial owner? They would be a control person, an individual who has a CEO, a director. That person would be a control person, yes.
The FinCEN number used for all KYC or only CTA. To our knowledge, only for CTA now. But if banks routinely are given access, maybe they'll start to use a FinCEN identifier too as a proxy. But as of now, there is not automatic access by anyone other than law enforcement agencies. So I just think it's so much easier to get a FinCEN identifier. And that a top-level ownership entity that wholly owns the operating company that otherwise qualifies for the large entity exemption. If there is a top parent company that is a large operating company, its wholly owned subsidiaries are all exempt. But if that top company, which often is a holding company, and so it's not going to be a large operating company because it doesn't have any employees, and that's the major reason why it's not going to be eligible. Whoever owns that entity, those are who the beneficial owners from an ownership point of view are going to be. So again, there is a lot of nuance, but I think our view has been, I mean, maybe it's easy for us to say, but possibly a little over-reporting until there may be more guidance and clarification on some of these open issues, because you're asking questions that everybody's asking, and all we have to go on is what's in the FAQs or the Small Entity Compliance Guide, both of which are on the FinCEN website. And I signed up for the updates on the FinCEN website. So if there are ever any updates to the FAQs, I get an automatic email from FinCEN telling me that, and I know same day. And so I find that good to know, because you'll see a lot of law firms are out there getting out client updates quickly because they've just seen that, like October 3rd, for example, there was an update. Pretty big update, actually.
There's just one more, there's obviously a number of questions, but one I think that is probably broadly relevant. So just asking about how the employee count and gross revenue work with respect to what I assume is large operating company exemption across affiliated and consolidated entities. So I think the short answer there is it doesn't work. The large operating company exemption relates to a single entity that has at least 20 employees and 5 million in gross receipts. The guidance that we have seen to date indicates pretty unambiguously that aggregating across a group of affiliates does not work for the purpose of getting the exemption.
I think we've come to the end of our time, so we will go back through the questions and plan to do a follow-up individually with people. So if you do have questions, hopefully, these are things that will be fairly easy, or if there's something further that would be needed, we'll say that to you as well. I just want to mention again our CLE code. It's SS, that's S as in Seyfarth, S as in Shaw, 8475. And we appreciate your attendance today. I think we will plan to have another webinar probably the first week of December, just to try to make sure we could get enough coverage for people who weren't able to listen. We're going to circulate the recording, we'll circulate the slides. There are links in the slides to certain of the resources. And we appreciate your attendance. Thanks very much, everybody.